Today I'm talking to Heather Beckett from Goldsmith Chambers about a recent court case, Ramdhean against Agedo and the Forum Dental Practice Limited. Heather, you're a barrister at Goldsmith Chambers. What type of work do you do?
I'm a member of the civil team at Goldsmith Chambers, and in particular the clinical negligence and healthcare team. The majority of my work concentrates on clinical negligence and particularly dental negligence. I also do some personal injury.
You particularly mention dental negligence. Is there any special reason for that?
Yes, actually. I was a dentist for many years before I became a barrister. In fact, I am still a registered dentist, a specialist in restorative dentistry on the General Dental Council register, and that experience really helps with a lot of my work.
So, the case of Ramdhean against Agedo and the Forum Dental Practice Limited, I'm guessing that's a dental negligence case?
Well, yes. Although the decision in January 2020 didn't actually address whether there had been any actual negligence, the really important and interesting aspect of the case is the decision relating to who would be liable for any negligence if that was subsequently shown. The dentist who treated the patient, Ms. Ramdhean, was Dr. Agedo. But the important outcome was that the judge decided that the Forum Dental Practice Limited, the practice where Dr. Agedo provided the treatment, would be liable to the patient for his negligence if that was subsequently proved.
Why is that so unusual? If the treatment was carried out at the Forum Dental Practice Limited, why shouldn't the practice be liable for negligent treatment?
Well, generally, the default position in dental negligence claims, where a dentist works at a dental practice instead of working, for instance, at a hospital, is that each dentist is regarded as an independent practitioner, and each dentist carries their own insurance or indemnity to cover them if something goes wrong and a patient is harmed through negligence. And that's to ensure that a patient can obtain redress. That actually often comes as a bit of a surprise, even to solicitors, but certainly to patients who think that they can look to a practice for recompense, particularly if the dentist has moved on or if they can't be traced. But it's important to remember that the default position, as I say, is that a claim needs to be made against a specific dentist.
But you say this case was different. Tell me about it.
Well, in this case, Ms. Ramdhean, the claimant patient, was referred by her own NHS dentist to the Forum Dental Practice Limited to have a wisdom tooth out. It seems that her dentist didn't do that type of work, but there was an NHS arrangement by way of a contract between the local primary care trust and the Forum Dental Practice Limited for this type of care. It was called an intermediate minor oral surgery contract. And under that, the Forum Dental Practice Limited was paid a fee by the primary care trust for each patient treated. Dr. Agedo had been engaged specifically by the company, Forum Dental Practice Limited, to service the specific oral surgery contract. The managing director of the company, Dr. Jackson, was himself a dentist, but he didn't do this specific type of work. Dr. Jackson's view was that Dr. Agedo was, like every one of his contemporaries across the country in similar roles, a qualified, self-employed, individually indemnified dental professional. Dr. Agedo took out Ms. Ramdhean's wisdom tooth, but she alleged that he left roots in, on not just one, but on 2 occasions, and eventually she had to go to the hospital to have the extraction carried out, and then she was left with some loss of sensation. It seems that Dr. Agedo didn't tell his insurers, so they declined to assist when Ms. Ramdhean intimated a claim against him. He was also at some point erased from the dental register, although that was for unrelated reasons, and the practice terminated his engagement, and then he disappeared. So that was that.
So why did the judge say that the Forum Dental Practice Limited was responsible and not Dr. Agedo?
Well, she didn't actually say that. What she had to consider here was two other possibilities. Firstly, whether the Forum Dental Practice Limited owed Ms. Ramdhean what's called a non-delegable duty of care when it accepted her for treatment, so that legally it couldn't offload its responsibility onto Dr. Agedo. And additionally, or alternatively, whether the Forum Dental Practice Limited was vicariously liable for the acts and omissions of Dr. Agedo, even though he was an independent practitioner. If either of those things was found to be correct, then Ms. Ramdhean could proceed with her claim against the Forum Dental Practice Limited, the company, and if she was successful in proving negligence on the part of Dr. Agedo, the company would be liable to compensate her.
How did the judge approach the issue of the non-delegable duty of care?
Well, in general terms, the judge explored and adopted the 5 factors which were set out by Lord Sumption in the Supreme Court case of Woodland and the Swimming Teachers Association and others. That's a 2013 case from the UK Supreme Court at number 66. These factors have characterised cases other than highway and hazard cases, which have given rise to non-delegable duties of care. The first factor is that the claimant is a patient or a child, and for some other reason is especially vulnerable or dependent on the protection of the defendant against the risk of injury.
Well, no problem with that then. What about the other factors?
Yeah, exactly. So, she was a patient, no problem. So secondly, there should be an antecedent relationship between the claimant and the defendant, independent of the negligent act or omission itself. Firstly, which places the claimant in the actual custody, charge or care of the defendant, and secondly, from which it is possible to impute to the defendant the assumption of a positive duty to protect the claimant from harm, and not just a duty to refrain from conduct which will foreseeably damage the claimant. Thirdly, the claimant must have no control over how the defendant chooses to perform those obligations. For example, whether personally or through employees or through third parties. Fourthly, the defendant has delegated to the third party some function which is an integral part of the positive duty which he has assumed towards the claimant. And the third party is exercising, for the purpose of the function delegated to him, the defendant's custody or care of the claimant and the element of control that goes with it. And fifthly, the third party has been negligent, not in some collateral aspect, but in the performance of the very function assumed by the defendant and delegated by the defendant to him. There is a sixth factor, which is that it should also be fair, just and reasonable to impose a duty when that is a financial burden upon those providing essential public services.
I can see how the fourth and fifth factors might fit the facts of this case. But what about the second and third? How did the Forum Dental Practice Limited assume a positive duty to protect Ms. Ramdhean from harm once Mr. Agedo was providing the treatment?
Well, it was really because Forum Dental Practice Limited was the contractor. Ms. Ramdhean was their patient, and under the contract with the Primary Care Trust, their patient, not Dr. Agedo's patient, and there was no mechanism whereby Ms. Ramdhean's NHS dentist could refer her direct to Dr. Agedo, missing out the Forum Dental Practice Limited. So the practice was critical in exercising a degree of control over Ms. Ramdhean. She was referred under the NHS arrangements because that was the arrangement whereby her dentist could effect her having her wisdom tooth taken out under the NHS. Then in reality, she didn't really have any choice about who the Forum Dental Practice Limited used to fulfil its obligation, they happened to fulfil it by asking Dr. Agedo to carry out the treatment. And in fact, they obtained a benefit from doing so because they were paid for every patient that was treated. The fact that it was a business that was paid for every patient also made it fair, just and reasonable that the identified non-delegable duty of care should be fixed on the Forum Dental Practice Limited.
So was there any need to consider the vicarious liability issue as well?
Well, the judge recognised that the finding that the company had a non-delegable duty of care, which made it liable for any tort committed by Dr. Agedo, might well have an impact on dental practitioners nationally because of the default position which I mentioned earlier. And therefore, the matter might go further. In other words, the matter might be subject to appeal. So she did feel it was necessary to consider the alternative basis by which the Forum Dental Practice Limited could be liable, because even if the appeal was successful in relation to non-delegable duty of care, it would be unlikely that it would be successful on both aspects.
And was the company vicariously liable?
Yes. The judge was clear that the basis upon which this assessment of the facts should be made was on the basis of the reasoning of the Supreme Court cases of Cox and the Ministry of Justice, 2016, that's UK SC 10, and Mohammed and WM Morrison Supermarkets PLC, again a 2016 case, and that's UK Supreme Court number 11. Both of those were approved subsequently in Arms and Nottinghamshire County Council, 2017 in the UK Supreme Court number 60. So there are two overarching questions. Firstly, what sort of relationship has to exist between an individual and a defendant before the defendant can be made vicariously liable for the tort of the individual? Here, pretty much the fact that the company was a business that should be responsible for business risks that it has itself created, and also that it had benefited financially from each patient being treated under the main contract, in fact, to a greater extent than Dr. Agedo did under the subcontract to him, meant that Forum Dental Practice Limited could be made vicariously liable depending on the nature of the tortious conduct complained of. So that then went on to the second question: in what manner does the conduct of the individual have to be related to the relationship in order for vicarious liability to be imposed? The answer was if there was a sufficient connection between the employment of the individual and their wrongdoing to make the defendant legally responsible.
But Dr. Agedo wasn't employed by the Forum Dental Practice Limited, was he? I thought he was an independent subcontractor.
No, he wasn't employed, but he'd been engaged precisely to carry out the treatment he was carrying out when the alleged wrongdoing occurred. He hadn't gone off on a frolic of his own, so to speak. The Supreme Court authority of Cox held that technicalities about actual employment status in such a situation are irrelevant.
How important is this case in the grand scheme of things?
Well, cases do tend to turn on their own facts. Here, there was a particular fact whereby a patient was referred under an NHS contractual arrangement where local arrangements on the part of the providing contractor meant that, in effect, the patient or claimant had absolutely no choice about who treated her. If the referral had been direct to Dr. Agedo on a private basis, she could at least in theory have said she would prefer to see somebody else and go elsewhere. The second thing about this case is it is what's called a first instance case, although it was heard by a circuit judge, so it's not necessarily binding on other first instance courts. However, it is important because it's a possible way which may exist, particularly in referral cases involving NHS intermediate service contracts, for a claimant to look to a practice principal or a limited company running a practice where a dentist doesn't engage with the claimant at all. It's also important, I think, because it demonstrates the application of the concept of a non-delegable duty of care, which is drawn from the case of Woodland that I mentioned earlier, and the readiness of the courts to apply the concept of vicarious liability in appropriate cases, which means that the courts, which have been extending vicarious liability in recent times, continue to be willing to do so.
And I suppose the Forum Dental Practice Limited had its own insurance anyway.
Well, no, actually, it doesn't seem as though it did at the relevant time, although the judgment suggests that it does now. It did have public liability insurance for people coming to the practice, but that didn't cover negligence on the part of one of the subcontracted dentists at the time. If the overall claim for negligence is successful, and of course we don't know whether it will be, I assume the company will have to cover that itself. That, in fact, is a practical and important lesson from this case for some dental practices, or the principles of dental practices, depending on how they're set up, because they may find themselves liable for the acts and omissions of associates, particularly if they take on NHS provider contracts and provide them via performer associates.
So the default position that an individual dentist is responsible for their own acts and omissions is still relevant, but this case may have just made an inroad into that.
Yes, very possibly.
Thanks very much.
Thank you. If you would like to get in touch with me for any dental negligence cases or any advice, please do contact me via my clerks at Goldsmith Chambers. The email is clerks@goldsmithchambers.com. Thank you very much.